I'd like to begin by going back a little bit of history regarding why we have a buffer zone. For those of you who remember, back in 1994, there was an incident over at the Planned Parenthood clinic here in Boston where John Salvi went in one day and shot and killed two women and wounded several others, and that was back in 1994. Several years later, in 2000, the Massachusetts legislature, after debating for several years on what to do, the state Senate, decided to implement a 25-foot fixed buffer zone around all abortion clinics. Before they did that, however, they asked the Supreme Judicial Court if in fact the law that they proposed was constitutional. Surprisingly enough, the Supreme Judicial Court decided it was constitutional, and that was in the spring of 2000. In the spring of 2000, shortly after that happened, the United States Supreme Court came down with the case of Hill versus Colorado. And in the Hill versus Colorado case, the Supreme Court of the United States upheld the Colorado law, which had a 25-foot fixed buffer zone with an 8-foot floating buffer zone. And what that really meant was that they drew a circle of 25 feet, a perimeter 25 feet around the outside of the abortion clinic, actually in the Hill case, around all medical facilities. And that becomes very important. Colorado has a 25-foot radius around all medical facilities, which is fixed, but within that 25-foot, they have the 8-foot floating zone, which means that a person may enter the 25-foot fixed buffer zone and approach a person within 8 feet to speak to them, to counsel them, to hand them literature, and to try to get them to change their mind before they go into the abortion clinic. Shortly after that, the legislature in Massachusetts decided that perhaps they should reconsider the 25-foot buffer zone, and they did, and the legislature passed an 18-foot fixed buffer zone with a 6-foot floating zone. And that was signed into law by Governor Cellucci, then Governor Cellucci, in 2000. And what that meant was that in Massachusetts, around any abortion clinic, and again, this law only applies to abortion clinics in Massachusetts, or as they call them, reproductive health care centers. Sort of a contradiction in terms, but in any event, around any reproductive health care center in Massachusetts, you had an 18-foot fixed zone with a 6-foot buffer, 6-foot floating zone. As a result of that, the people who counseled, went out every day to talk to women trying to change their mind on abortions, were able to walk inside the 18-foot zone and to counsel, to talk to these people up, as long as they approached them, didn't approach them any closer than 6 feet. They could walk up to them, they could talk to them. For example, Eleanor McCullen, who was our chief plaintiff in this case that we're now going to the Supreme Court with, she could walk up to a young woman, a middle-aged woman, any woman going into the Planned Parenthood clinic to have an abortion, and say to her, have you considered any alternative? Here's some literature. Are you being forced? Is your boyfriend or your husband pressuring you into having the abortion? If you are, I can help you. I can give you some money. I can give you a home while you're pregnant. I can give you baby clothes. Eleanor McCullen has testified that during the time she was doing this, she and her husband have spent over $50,000 of their own money to help young women, and they have helped hundreds of young women. In any event, the law was put into effect. It was challenged. It went to the court. It went to initially to the Federal District Court in Boston. Judge Ted Harrington, who a fellow Holy Cross graduate, immediately found that it was wrong, and he put in an injunction. That was immediately appealed by the Attorney General, and at the First Circuit Court of Appeals, his injunction was removed. He was overruled, and it went back for a hearing. The case was then held, the judge held that, and that case was called the McGuire case. That was held that the law was constitutional. It was again challenged twice to the First Circuit Court of Appeals, But in both cases, the First Circuit Court of Appeals upheld the lower court. They attempted to go to the Supreme Court for certiorari, and the Supreme Court denied the request for certiorari on the McGuire case. And so as a result, from 2000 to 2007, the law that I had just explained to you, which was 18 feet fixed, 6 feet floating, went into effect. And in fact, it pretty much worked. The people like Eleanor McCullough, Gene Zarella, Eric Caden, the people who are now fighting this law or not, that we're fighting for, they were able to go out to the Planned Parenthood clinic at the Alston-Brighton line on a daily basis and counsel women. They were able to go within 6 feet of them, they could talk to them, they could hand them literature, they could pray for them, they could do any number of things. And for 7 years, it effectively worked. In fact, during that 7-year period, there was never a conviction. In fact, there were very few even problems with the police during that period of time. No one was ever convicted during the 7 years that law was in effect in either a state or federal court. And then in November of 2006, Governor Deval Patrick was elected as governor. And in January, immediately or right after he was elected, the state legislature heard from Attorney General Martha Coakley, Planned Parenthood, and a Democrat from Medford by the name of Carl Scortini, who decided that the buffer zone wasn't working very well, and so they decided that they wanted to have a new buffer zone, which was in fact a 35-foot fixed buffer zone. So that now instead of 18 feet, 6 feet floating, this was a 35-foot perimeter around all abortion clinics, and no one could enter that. In fact, if you did enter into it, you were subject to up to 3 months in jail and a $500 fine for the first offense, and 30 months in jail up to $5,000 for a second offense. So these people who go out on a regular basis and protest and try to help and counsel women, none of them wanted to take the chance, and so effectively, no one has stepped within inside that 35-foot buffer zone since 2007 when it was passed. In early 2008, in January of 2008, a number of people approached us to see if we would file a case, and so we did file a case. It's known as Eleanor McCullough, Gene Zarella, Gregory Smith, Eric Caden, Cyril Shea, Mark Bayshore, and Nancy Clark versus Martha Coakley as the Attorney General in her capacity as Attorney General of the Commonwealth. And we basically we challenged the law because we said it would we didn't want it to go into effect. The other one was working. Why didn't you just leave this one alone? But anyway, the basic law as it stands after 2007 said that no person shall knowingly enter or remain on a public way or sidewalk adjacent to a reproductive health care facility within a designated and clearly marked buffer zone. The buffer zone spans a radius of 35 feet of any portion of an entrance, exit, or driveway of a reproductive health care facility or within the area within a rectangle, and this is really interesting if you can understand it, a rectangle created by extending the outside boundaries of any entrance, exit, or driveway of a reproductive health care facility in straight lines to the point where such lines intersect the sideline of the street in front of such entrance, exit, or driveway. What? I don't know what anybody really knows what that means. In fact, if you look at any of the facilities that are included in this, which are 3, Boston, Worcester, and Springfield, none of them have these intersecting lines. They all draw a radius because I don't think even the people who wrote the law can explain what the second half of the law means. Then we get to the really important part beyond the 35 feet. There are 4 categories of people who are exempted from this law. The first people who are exempted are persons entering or leaving the facility. The second is, and this is really the important one, employees or agents of the facility acting within the scope of their employment. The third are law enforcement, ambulance, firefighters, construction workers, utility workers, public works employees, and other municipal agents acting within the scope of their employment. And finally, persons using the sidewalk, street, or right-of-way adjacent to the facility solely for the purpose of reaching a destination other than the facility. In other words, if you were walking down the street and you want to walk in front of the sidewalk in front of the facility, as long as you don't say anything about abortion or don't speak to anybody, you can do so. Now, in January, 2 weeks after we filed this legislation, less than 2 weeks, Martha Coakley writes a letter to, quote, summarize the act and give guidance to assist in implying the 4 exemptions. I'll get back to this in a little bit, because this, we believe, in law we call it a smoking gun. And this is, and will be, and has, hopefully will be, one of the smoking guns before the Supreme Court of the United States. In May of 2008, we had a hearing. Actually, right after we filed the suit, we had an initial hearing with Judge Toro, and we agreed to bifurcate the case, which means there are 2 ways to challenge a law on the Constitution. One is to challenge it facially, which means that on its face, it is unconstitutional. And the other, if that doesn't work, you have, is it unconstitutional as it's applied? So we agreed, all parties agreed, the Attorney General and the counsel, there were 3 counsel at the time, Mark Rienzi, Mike DePrimo, and myself. We agreed for the petitioners that we would bifurcate the case. We'd split it in 2. We'd have 2 separate hearings. The first hearing would be whether or not the case was facially challengeable, and if not, then we would go back and do it as applied. After a hearing on the merits in August of 2008, we believed that it was unconstitutional, and some of the reasons we argued at that time in front of Judge Toro was that the loss of First Amendment freedoms for even a minimal period of time constitutes irreparable injury. The second is that the public ways affected by the Act are quintessential public forums for expressive activities guaranteed by the 4th and 14th Amendments. 3, the right to engage in peaceful expressive activities, assembly and association in quintessential public forums is guaranteed, again, by both the free speech assembly clauses of the 1st and 14th Amendments of the Constitution. 4th, the right to peacefully distribute literature in a quintessential public forum is guaranteed by the free speech and free press clause of the 1st and 14th Amendments. 5th, the right to engage in prayer, worship, and religious song in quintessential public forums is guaranteed by the same free speech and free exercise clauses. The fact that certain messages may be offensive to some of their recipients does not deprive them of constitutional protection. This one I find interesting because during the public hearings on Beacon Hill, public hearings, I think the only one they heard from were people who supported the bill, but Representative Scortini in his testimony said that the act that was in effect is totally unenforceable because one day when he was there, within the buffer zone, within the 6-foot perimeter, someone called him a baby killer. And he said that they couldn't arrest him because he was inside the perimeter. Well, I'm sure he wouldn't have been arrested in any event, whoever said it, because the Constitution allows you to say certain messages that someone may find offensive. So I guess Scortini found being called a baby killer was offensive, even though that's basically what he is. The truth hurts sometimes. The right to receive information is guaranteed by the 1st and 14th Amendment. The Act, we said, infringes on the right of willing recipients to receive literature and oral communications, because a lot of these women during the original bill, they were willing to listen to Jean and to Eleanor. They walked over to them, they talked to them. they took their literature. They actually, many of them walked away, changed their mind. But now, you can't talk to them unless you're inside a 35-foot buffer zone. And for those of you who are familiar with the Austin-Brighton Planned Parenthood facility, 35 feet puts you out into the street.
That's
So-
where we are in Springfield, in the middle of the road.
Well, it's worse in Springfield. I'll get to that why that's even worse. But these people have to, if you want to stand within 35 feet, you have to stand in the street. And so that means you're now on the other side of the street, which actually makes you probably 75 or 80 feet apart. However, they didn't find that to be a problem. The next one argument we made was that the right to travel and remain in the public place of one's choice is an aspect of personal liberty guaranteed by the 14th Amendment of the United States Constitution. And the next was even the right to loiter for peaceful purposes or innocent purposes is an aspect of personal liberty guaranteed by the Constitution. Abortion is a core political speech which one is allowed to argue about. The First Amendment forbids government suppression of political speech based on the speaker's identity. The next argument we made was that the Act unconstitutionally makes persons falling within its exemptions, including clinic employees and agents, preferred speakers while making plaintiffs non-preferred speakers. The next we argued was that the Act suppresses political speech on the basis of speaker identity. Then we argued that the defendant Coakley purported to interpret the Act to apply to clinic employees and agents within the scope of their employment if they engage in speech within a particular content, namely speech related to abortion or other, and remember this word, partisan issues. The next was the First Amendment does not permit a facially unconstitutional statute to be upheld based on a governmental promise of prosecutorial even-handedness. Next, we argued the plain text of the Act grants clinic employees and agents exemption and therefore an absolute defense to prosecution. And then we said that defendant Coakley's broadening of the statute through administrative interpretation violates the due process clause of the 14th Amendment. Now, when I mentioned the smoking gun, on January, we had filed this, I believe, on January 16th. On January 25th, the Attorney General of the Commonwealth sent a letter to law enforcement and personnel of the reproductive health care facilities subject to the Act's coverage. The letter summarized the Act and emphasized that the Act's provisions were in effect only during office hours or business hours and only if the boundaries were clearly marked and posted. So in other words, the first thing she did was to say that if the people running the clinic didn't paint a radius around the clinic and didn't post the law so that everyone could see it, then it wasn't in effect. So for example, at the Union Hospital in Lynn, or the building adjacent to Union Hospital in Lynn, there is an abortion facility there, but it's not posted and there's no circle, so that those people who protest 40 days can actually go up and stand right on the front steps and try to talk to the women. However, they don't. They, for some reason, choose to stand 35 feet away. But the letter also provided guidance to assist them in applying the 4 exemptions. Now, this is 2 weeks after we filed suit. The law was signed into effect on November 13th by Governor Patrick, and he put an emergency preamble on it, which meant it went into effect that very day. We don't know what the emergency was, but he evidently felt it was. Now, a little less than 2 months later, we file our suit. Less than 2 weeks later, the Attorney General, after reading our suit, writes a letter explaining what the bill means. And she said the first exemption for persons entering or leaving the clinic only allows people to cross through the buffer zone on their way to or from the clinic. It does not permit companions of clinic patients or other people not within the scope of the second or third exemptions, which we'll get to in a minute, to stand or remain in the buffer zone, whether to smoke, talk with others, or for any other purpose. The second exemption for employees or agents of the clinic acting within the scope of their employment allows clinic personnel to assist in protecting patients and ensuring their safe access to clinic, and get this, but does not allow them to express their views about abortion or to engage in any other partisan speech within the buffer zone. So what the Attorney General is saying is that even though these people are exempted, the clinic, or these people who help the agents who wear blue, look like life jackets and try to whisk the women in, they can't mention abortion, or they can't encourage the women, or they can't say what they usually say, which is don't listen to those people, they're wacko. So this was what she said would happen. Now, of course, what I just read to you was that the law itself is so plain that if anybody attempted to prosecute an agent of the clinic for violating Attorney General Coakley's message, it would be a total waste of time because the act itself is so specific that you can't change the act. Then she went on to say the third exemption for municipal employees or agents does not allow municipal agents to express their views about abortion or to engage in any other partisan speech within the buffer zone. Interestingly enough, when they talked about partisan speech, and this is sort of an aside, I'm jumping forward a little bit, we were at the First Circuit Court of Appeals in Boston when we were arguing after Judge Toro had ruled against us. And one of the judges who was there was a judge by the name of Judge Jensen. And he was here by designation, as they say. He's not a member of the First Circuit. He was in here from Cleveland because, according to his own testimony, the reason he was here is he's a very Cleveland Indians fan. And the Indians were in town playing the Sox. And so he happened to be here, so they asked him if he wanted to sit in on the case, and he said yes. And one of the questions he asked the Attorney General, when the Attorney General was arguing this case, was, assuming we say that the word, he said, what does the word partisan mean? And the assistant kind of fumbled around and tried to explain what it meant. And he said, well, I'm very partisan to the Cleveland Indians. Does that mean if I walk through the zone today with a Cleveland Indians hat and a Cleveland Indians shirt on that I would be violating the Attorney General's letter? And the guy thought for a minute and he said, yes, it would. That's how bad he said that the case would be. Of interest was that when the decision came down, it was written by Judge Selye, Judge Jensen excused himself from the case. And they asked, that came up in the decision by Judge Selye, and they asked him about it, and he said, well, even though that's a real problem, you guys didn't bring it up during your argument at the district court, so you can't raise it on appeal. So that argument, even though it's a good one, we're going to waive that one. So, but that may come up later on at some other point. In any event, despite what we felt, and I just went through all the reasons we felt that the law was unconstitutional, we felt that these arguments, for the most part, were really good. We thought we had good First Amendment arguments. We thought we had great 14th Amendment arguments. However, Judge Toro chose he ruled against us on every single issue. We appealed to the First Circuit Court of Appeals, and they found against us also in a somewhat derisive opinion. Judge Selye is kind of a wise guy. To be honest with you, Mark Rienzi, who argued the case at the Supreme Court, argued the case in front of Judge Selye. He came up from the Columbus University Law School at Catholic University of Washington. He also argued the McGuire case. So Selye and Rienzi know each other somewhat. And Selye said to him, you know, I think you're very bright, Mr. Rienzi, and you make good arguments. He said, I totally disagree with all of them. And some of the things he said in his decision was that we were whistling past the graveyard and other such comments, which I felt were somewhat derogatory. But anyway, we lost. After we lost at the First District Court of Appeals on the facial challenge, we went back and argued the second case, and that was as applied. And the only thing that Judge Toro would allow us to argue was whether or not we had adequate alternatives of communication. And this was very interesting because we had the testimony now of all of the people, all of our plaintiffs, who said, you know, we just can't argue, we can't do the same thing. We're 35 feet away, and in some cases, like in Springfield, we're a quarter of a mile away. In Worcester, it's even worse because the facility is blocked, and we can't even see the people entering the clinic. And Dr. Shea out in Springfield said, I can't even get near these people anymore. It's a big, huge facility. They've got all the driveways blocked. I can't even get there. And Gene and Eleanor said, we can't talk to these people anymore. Judge Toro said, well, you don't need to, you can use a bullhorn. You can stand 50 feet away and use a bullhorn. How many people do you think, how many women who are in a very unique situation, very, very sad day for them, they're confused, they're frightened, and somebody is yelling at them with a bullhorn, and this is going to make them go over and say, can you help me? They're frightened. Plus, as I say, the clinic employees are saying, don't listen to these people, they're crazy, they're wacko, they're religious fanatics. Look at that guy, he's saying the rosary, look at that guy, he's dressed up like some crazy outfit. This is not a very helpful way. In fact, Jean Zarella said that during the 2000 Act, from 2000 to 2007, she testified that she had actually changed the mind of over 100 women during that 7-year period. She said, since the new law has gone into effect, I have not been able to change one person's mind. In fact, I can't even talk to most of these people. So there is a major, major problem. Anyway, so we go back, we argue, we had photographs, we showed what I thought was an outstanding presentation, because actually at the First Circuit, when they denied our first appeal on the facial, they said, we're denying this at this time, however, if you come back with some really good evidence on the as applied, we may reverse ourselves. Well, we did come back with some really good evidence, but guess what? They didn't reverse themselves. However, we decided enough is enough, so in March, we filed our petition for certiorari, and as of last Monday morning, thank God, the Supreme Court, despite a bad week at the Supreme Court, they did one thing right. They granted our petition for certiorari. So we will be going to the Supreme Court. We have 45 days to file our brief, most of which has already been done because we pretty much have argued it. The Attorney General then has 30 days to reply. We have 15 days, I believe, beyond that to file our reply brief, which takes us out to sometime in October. So I would assume, we're guessing, but we assume that we will be arguing the case before the Supreme Court of the United States in late November or early December, and that sometime next spring the decision will come down. And hopefully at that time they will find that the Massachusetts law is unconstitutional. The questions that we presented are as follows. Massachusetts has made it a crime for speakers to enter or remain on a public way or sidewalk within 35 feet of an entrance, exit, or driveway of a reproductive health care facility. The law applies only at abortion clinics. The law also exempts, among others, clinic employees or agents acting within the scope of their employment. And in effect, the law restricts the speech of only those who wish to use public areas near abortion clinics to speak about abortion from a different point of view. Petitioners are individuals who believe that women often have abortions because they feel pressured, alone, unloved, out of options. Petitioners try to position themselves, their clinics, in an attempt to reach this unique audience at a unique moment to offer support, information, and practical assistance. They are peaceful, non-confrontational, and do not obstruct access. Yet the state prohibits them from entering or standing on large portions of the public sidewalk to offer leaflets or to seek to begin conversations with willing listeners. The questions presented are, one, whether the First Circuit erred in upholding Massachusetts selective exclusion law under the First and 14th Amendment on its face and as applied to petitioners. Two, if Hill versus Colorado, a 2000 case I referred to earlier, permits enforcement of this law, whether Hill should be limited or overruled. Now, the Hill case is important because both the district court and the Court of Appeals stated that they relied heavily on that case to make their decision. Yet the Hill case, there are three critical safeguards presented. One, equal applicability to all healthcare facilities. Two, equal applicability to all speakers. Three, narrow tailored application only to close unwanted physical approaches. All three are absent in the Massachusetts law because the law in Massachusetts applies only to abortion clinics. Two, the law in Massachusetts permits speech by clinic employees and agents while excluding speakers who advocate alternatives to abortion, despite what Martha Coakley says. Three, completely excludes disfavored speakers from otherwise public areas, banning even consensual speech with willing listeners. The First Circuit decision sustaining the Massachusetts Act as content neutral, it also directly conflicts with a Ninth Circuit Court of Appeals decision called the Hoy case. Hoy versus the City of Oakland. There, the Oakland enacted a no-approach zone similar to the one upheld by the Supreme Court in Hill. In response to an initial legal challenge, the city amended its ordinance so that on its face it did not discriminate against speakers. However, the city did not enforce the law against individuals who sought to facilitate access to abortion clinics. In other words, Oakland's enforcement policy was the same as Massachusetts' statutory exemption for clinic employees or agents. The Ninth Circuit sustained Oakland's statute on its face, but invalidated the city's policy of differential enforcement on the as-applied challenge. In a decision written by Judge Berzin for herself and two other judges, the court squarely held that the city's policy of distinguishing between speech that facilitates access to clinics and speech that discourages access is not content